Good morning, everyone, once again, and thank you for joining. I'm Davina Gowden, the Communications Coordinator here at RPRA, and welcome to RPRA's Ask the Registrar session on the amendments to the Blue Box regulation. And during our webinar, we'll also be answering your questions. So to ask a question, you can click on the Q&A tab, type in your question or comment, and click Send. There is also an upvote or a like feature where you can like another person's question. You'll see it when someone submits a question. There's a small thumbs up next to it. And if you see a question that maybe you would like to ask or would really like to be answered, you can like the question with the thumbs up, and this will move the question up the queue and prompt us to answer it faster. We also have quite a large number of participants in this webinar, so it is possible that we won't get to all the questions during the allotted time. And if we can't get to your question, or if it is very specific to your situation, we will either follow up with you after the webinar, or you can email registry@rpra.ca. And now I will hand it off to Mary Cummins, RPRA's Registrar, as well as Michelle Axby, our Blue Box Coordinator, to kick off today's presentation. Thanks.
Perfect. Thank you very much, Davina, and welcome everyone. So I think most folks who have joined this webinar understand the topics that we'll be covering today. You want to talk a little bit about what we won't be covering, just so folks know where they can go to get more information if they're sort of jumping into this net new. So we're not going to be covering details that are in the current regulation that don't impact the regulatory amendments that were recently made. We're not going to be covering detailed questions around reporting or am I obligated? Is this obligated? How do I report that? Unless it specifically relates to those amendments. So I think newspapers you'll see in a moment will probably have some areas around how do I report this? Is this obligated? How is this treated now? So we'll certainly address those. But I just want to make sure everyone understands that the scope of today is really about the overview of the Blue Box regulatory amendments. If you have questions about who is RPRA, what is our role, what is our approach to compliance, how do I report, how do I register, am I a producer? We have many pre-recorded webinars on our website, and I'd encourage you to go and peruse those. And there's also resources that we'll cover at the end where you can contact the team to walk that through. Today's scope is quite narrow, given the time limitations that we have. So let's go to the next slide, which is the overview of the Blue Box regulatory amendments. Next slide. So first, just to set the framework, to remind everyone where we came from, the Blue Box regulation was released last June. That regulation transitioned producers from Stewardship Ontario's program into the new IPR framework under the Resource Recovery Circular Economy Act. And so what you've got here is that municipalities will start transitioning July 1st of 2023, with that transitioning ending in 2025. So just a reminder of what regulatory amendment occurred, which regulation it occurred to. Next slide. So really you can boil down the amendments to three key areas. So really the first one is around this concept of rules creator and the rule creation process and the associated allocation table that came from the rules. We'll talk about what that is and how it's gone, and how instead it's been replaced with this concept of each producer is responsible for providing a complete network across Ontario. So every producer is now responsible for every eligible source in Ontario. So we'll talk about what that change looks like and why, with more of a focus on what producers can expect going forward. Instead of having rules being submitted by rule creators, you also have now pros being required to submit what the regulatory amendment calls a report to RPRA on how they're going to operate the Blue Box system. We'll talk, there's a few slides coming up about what exactly that report looks like, who submits the report, what RPRA does with the report, and what the report means. And then lastly, there's an exemption for newspaper producers, but only newspaper producers whose total Blue Box supply is at least 70% of their total. So it doesn't apply to newsprint per se, it applies very specifically to a definition of newspaper, which we will cover. And it also only applies to those who are for the most part, fairly exclusively newspaper producers. So next slide. The scope of the amendments didn't have a lot of impact on producers for the most part. Those amendments had no impact on anyone who had to register. So even newspaper producers who have that meet that 70% threshold still are required to register with RPRA, and we'll talk about that more. Doesn't impact the 2020 supply data reporting. So that supply data reporting was due to RPRA last year. This amendment is going forward. So for instance, when we talk about it in a little bit about the newspaper exemption, we're talking about exempting newspapers from performance requirements. The 2020 supply data didn't set performance requirements. It was for a different purpose. There's no exemption applied for newspapers for the 2020 supply. It's the 2021. It says most producers will not have an impact. If you are not a newspaper producer primarily, so you don't have over 70%, and again, we'll have a definition in a moment for you, you have no change whatsoever to what you're going to be reporting to us come October 31st is the deadline. There's no change to processor registration that was due to RPRA April 29th. I know the team has been talking one-on-one with many companies about, whether they need to register or not. If you are a blue box processor and you're talking to the team, that is great. If you think you are a blue box processor and you're not talking to the team, please contact them immediately so you can start to have those conversations. It doesn't impact, none of the amendments impact any scope of the material of what's actually collected. So we'll get into this more, but even though newspaper producers have an exemption from performance management, that doesn't mean consumers can't put newspaper into their blue bin. Doesn't change collection requirements, doesn't change any of the schedule or its timelines. So the vast majority of producers, this has no impact. So I just want to make sure folks understand that if a producer is sitting on the line trying to figure out what this means to me, this is a very limited scope change to the blue box regulation, and it may have absolutely no impact to you. It will impact your pros and how you're working with pros. So we're going to talk about that a bit as well. Next slide. So let's talk about that now. So under the previous, before the amendment, if you will, the blue box regulation outlined this process involving rule creators. Rule creators were just pros who offered a specific service for creation of rules. This rule creation process outlined 10 things that the rule creators had to land on how the collection system, how the entirety of the eligible sources of all of them in Ontario were going to be divvied up amongst different producers. These rules were then given to an allocation table maker, and an allocation table would have been made that said, here's the different locations across Ontario, and here's the different producers responsible for those locations. Instead now, each producer is responsible, so this amendment has made it so that each producer is responsible for providing blue box collection to every eligible source. So before, if you were a producer, you might have gotten assigned through this allocation table 20 locations. You are now responsible for all of the eligible locations across the province. This is actually similar to the way the other regulations work. So for instance, Tires has the ability for, just like now the blue box regulatory amendment, Tires has the ability for a single producer or a single pro to set up a compliant network to say, here is my entire system, or they can work together and set up one common system, right? So the choice is now in the blue box regulation with this amendment. Next slide. So that covers that first of those three key amendments we spoke about. The second one on that slide around this initial report, what the regulatory amendment calls a report. It is not a program plan for those familiar with the old IFO program model. It is not an actual program plan. It is a report that needs to be submitted to RPRA by July 31st and includes very specifically these three things from the regulation. Next slide. Who submits the report? It's a report, as it's called, an initial pro report by the pros or multiple pros who work together through an agreement. The pros must represent 66% of the aggregate weight of blue box material supplied to consumers in Ontario from 2020. So of all of the data that RPRA collected in last year on the 2020 supply data, that's our denominator now. Everything that was reported. No more rule creators. So it doesn't matter if a producer selected a rule creator, they've reported that data, that's part of the denominator. If a pro had an agreement to represent a producer, that's what the numerator is of that 66%. RPRA receives this report. RPRA does not approve it. The minister does not approve it. There is no role for anyone in that. RPRA simply receives it, confirms that 66%, and promptly posts it on our website. There is no other steps or process involved. It is then available publicly for everyone to see how one pro or pros are working together to deliver the system. Next slide. Okay. So newspaper producer exemption. So as I mentioned, this only applies going forward. So there's no adjustments required to any newspaper producer 2021 report to us with their 2020 data. Because what the exemption is that a producer is coming in and they may be exempt from collection and management and P&E. They're not exempt from reporting. They're not exempt, and you'll see this on a later slide, from inspection or verification or any of those processes. They're exempt specifically if all of what they supplied, that is blue box material, is more than 70% of it is newspaper as defined in a later slide. If that is the case, they're exempt from collection, management, and P&E. So I think you can understand that doesn't make sense for it to apply to 2020. The 2020 data was not used to calculate collection, management, or P&E requirements. It will be the 2021 data coming to RPRA with a deadline of October 31st this year that is being used to calculate the next year's collection, management, and P&E requirements. So that's why it's not a retroactive thing. There's really no point. There's no exemption that would be applied, even if newspaper producers came in and reported this data this way. It's irrelevant because that's not what the 2020 data was for. Next slide. So as I said, for this area, it's a narrow exemption. If you're a newspaper producer who supplies more than 70% of your total blue box material is newspaper, you're exempt from collection, management, and P&E. You still have the fact that it's an obligated material under the regulation, still required to be collected in the blue box system. Newspaper producers, regardless of being over or under that 70%, still report to RPRA, and they're still subject to all of our compliance and enforcement activities, including inspections. Next slide. And here is the definition of newspaper. So we've received at least one question that won't be covered today around what is an insert that we are working through with the team and legal counsel and figuring out what is defined as an insert within the definition of newspaper. As I said, producers aren't coming in. The registry, the electronic registry, doesn't open until October 1st this year with a deadline of October 31st. So we do have time to get that definition of what an insert is out to folks. We're developing it as an FAQ, and it will be posted on our website, and we will notify producers when that update comes available. Next slide. Important reminders. So first, as I said at the beginning, not talking much here about how to report, what are your regulatory requirements, am I a producer, is this material in or out? If you have those sort of questions, you should contact the compliance team. We're noting that the producer registration deadline was October 1st of last year, when producers came in and reported 2020 supply data. Even if you're a newspaper producer, that deadline and that data is still required. And if you have questions about it, if you haven't submitted it, if something has happened and you're not already working directly with a compliance officer, contact the team as soon as possible. As I mentioned on previous slides there, the 2021 supply reporting data portal is not yet opened. It will open October 1st of this year with a deadline of October 31st. And that is where newspapers will see, producers will come in, they're going to report, and there'll be a guidebook associated with this to help folks. You're going to come in, you're going to report your blue box material, and then you're going to indicate what percentage of that blue box material was newspaper print as defined on that previous slide. noting that you are still subject to our compliance and enforcement activities, which includes inspections, verifications, requirements to receive documentation and evidence. Next slide. So we're moving on now to questions we have received to date. We haven't actually received too many questions to date, which is fine, but we have committed that we were going to cover every single question we received. Every question is in fact on these slides, with the exception of a few that were incredibly repetitive. We just summarized it into one question. If your question hasn't been answered here, feel free to throw it out and we'll make sure it has. In fact, even please indicate that so that we know to get that to you, because we did ask for questions in advance. So if we've made a mistake and haven't included it, please make sure to let us know. If, as Davina said at the outset, if we don't get to all of the questions, although this was purposely designed to be a short presentation with time for questions, if we don't get to the questions, we will make sure to get back to you. I will note if it's a very detailed question, we may have to refer that to the team, and so I'll let you know that that's the case. If we have time and there's questions that don't relate to these regulatory amendments, happy to entertain those as well. But I think we need to prioritize the regulatory amendment questions. So Davina, do you want to cover the questions we've received so far?
Definitely. Before we dive into the questions, I just want to have a reminder out there that the session is being recorded and that the materials will be shared with participants after the session. Okay, so the first question that we've received about the PRO initial plan is, who is responsible for approving the report and what happens if it is not approved?
So I mentioned this earlier, but just for perfect greater clarity, no one approves this report. It is something that is submitted to RPRA and we post it as a communication vehicle. That is it.
And what happens if the July 1st deadline for PROs to submit the report is not met? And would it give rise to a risk that Stewardship Ontario may be responsible for the Blue Box program as a result?
I think I'll deal with that question with Stewardship Ontario directly. So sorry about that. That's a question that I think Stewardship Ontario and RPRA and the transition team and Wilson, who leads that team, can probably better address.
Sure. So we'll go to the next question. Could you please advise whether there would be opportunities for producers to join any discussions around program design in light of the new amendments? Would producers be able to take part in any discussions pertaining to the design of the system now that allocation tables and rulemaking process is no longer applicable? Or will these discussions strictly involve the PROs?
That's a great question for a producer to ask their PRO. There's nothing in the regulation that states that, so RPRA doesn't have a role in this process. And so if I were a producer who had that question, I would bring that question forward to my PRO to find out if there's a role for me to play.
Perfect, thank you. And the last question we have here is, are the weight of compostables excluded from the calculation of whether a PRO or PROs represent 66%?
So I think this question's coming from the fact that previously with the rule creation process, they were. Now with these regulatory amendments, they are not. So any compostable material that was reported to RPRA as part of that 2020 supply data, if you had an agreement with a PRO, that data will, and I will note there's a date, I believe it's April 1st. So you had to have had this agreement by with a PRO by April 1st. If you don't have an agreement with a PRO, you can't now go get one. Something really important to clarify, actually. So there's no action for a producer who's sitting there saying, I didn't have an agreement. If you didn't have an agreement, you don't have an agreement. And so now that 66% though does include the weight of compostable material. Okay.
We also received some questions about the rule creation process. So in the amended Blue Box regulation, rule creation is no longer a service provided by PROs to producers. Could you please clarify this and the impact on producers and or the Blue Box system?
Yeah, so we spoke about this a little bit. So without the rule creation process and rule creators, there's no allocation table. The allocation table was what drove saying this producer A is allocated these 150 locations in Ontario. Instead, now that impact is much like it is in other regulations. So tires regulation, batteries regulation, ITTAV all have the same concept. There is a requirement to have a collection system. A producer or a pro can say, I'm going to create that collection system, and this is compliant, or they could work together to submit one common collection system. So that's the impact, is that no longer will one producer be allocated locations that they're responsible for, and instead every producer is collectively responsible for the whole system.
Okay, and now we'll move on to questions we received about newspapers around producer registration and reporting. So the first question we have here is, if a producer meets the 70% weight threshold, are they exempt from registering and reporting blue box tonnage and payment of RPRA fees associated with that tonnage?
Yeah, so producers are still required to come in, report their total blue box material, and then indicate to RPRA what percentage of that tonnage, that blue box material, met the definition of newspaper. If they're over the 70% threshold, so 70% of the blue box material that they've reported to us are above that threshold, they're exempt from, very specifically, collection, management, and P&E. That is it. They're not exempt from registration and reporting. Obviously, they need to come in, register, and report that so that we can tell them if, in fact, they are exempt from collection, management, and P&E. Right now, our board is has just wrapped up a consultation on the RPRA fees. So once those fees come out and are final and approved by our board, folks will see if our board decision regarding this. However, the fees that were consulted on did not include a different fee or anything like that for newspaper.
The next question is, how should a transitioning municipality that is also a producer report on newsprint? Is it by weight or management cost?
Right, so more information will come forward for any newspaper producer, including a municipality who is a producer. I don't know that any municipality who is also a producer will have more than 70%, that exemption will apply to them, but perhaps that is the case. And you're coming in, all producers, regardless of whether you're a municipality or not, you're coming in, you're reporting on all of the blue box material you supplied, and you're indicating what percentage of that blue box material supplied is newspaper in accordance with the definition.
Thank you. So the last question on this slide is, our understanding is that newspapers who qualify as small producers with less than $2 million in revenue are not required to register and report to RPRA. Can you confirm that this interpretation is correct?
It is correct, and it is correct for any producer, newspaper or otherwise.
Great. So we have more questions about newspapers, but this is more on reporting targets. So now that other producers will be picking up newsprint, will there be a target for newsprint recovery, and how will it be enforced?
Yeah, so unless there's a target in the regulation, there is no target, and there is no target in the regulation.
Thank you. And so who will define how newsprint will be reported? If it's individual producers or pros, there are concerns about transparency. It would be helpful to have a directive from RPRA setting out for all producers how newsprint will be dealt with.
So the registrar has, under our statute, the ability to issue registry procedures on how data is to be reported into the registry, which is exactly what I think this question is getting at. So it's not individual producers or pros that have that authority, it's the registrar. So we will be providing the direction. I've given it to you verbally. You're coming in, everyone will report all blue box material supply, and you're going to indicate what percentage of that was newspaper. So that's at a high level how the mechanics of the reporting will look. There will be a guidebook issued that'll walk folks through so that it's done consistently. As I said on previous slides, even having that exemption, so over or under 70%, does not remove a newspaper producer's obligations to respond to inspectors' inquiries, to be subject to a field inspection, to produce documentation, to answer questions, to perform verifications of that data. So all of that is still applicable to newspaper.
And the last question we have is, will newspaper producers who are exempt have to report their resource recovery performance?
Good question. So if they're exempt from performance, they have no resource performance, recovery performance. So they have nothing to report. They're exempt from performance.
Perfect. And now that brings us to our open Q&A. So we have quite a few questions in our Q&A box. So I'll start off with, will you post the market share each pro represents?
So we've, pros themselves have requested this information and we have provided it to them. If you have a question about what a private company's market share is, you should ask them and not the authority. So no, we won't be posting that sort of information publicly, but they have it and you can certainly ask them.
We have quite a large question, so I'm going to break it up into a few parts here. Okay. So this question says, we've been made aware that CMO would be the only pro forwarding MSA/SOWs to Ontario municipalities. This was a surprise to us as we thought we would have potential choice between pros. Such as CMO, RISE, RRA. Is RPRA aware of this, and does this differ from the intent of the legislation whereby there would be a choice?
So I don't think the regulation says that there'll be a choice, but I do, and I'm not aware of what private contractual market arrangements are occurring between pros or service providers, including municipalities. That is between the producers, their pros, and the municipalities and the service providers.
Perfect. And the second part of that question is, we've also heard that CMO would not be offering processing MSA/SOW, as that would or may come from other pros. We have not yet received anything on processing from anyone. This makes it difficult for a municipality to make a comprehensive choice and report to council in a manner to meet the CMO timeline of June 30th. For the request of confirmation back on collection. So can RPRA provide us with additional guidance, please?
So this might go to a little bit of what RPRA's role is. RPRA does not get involved in these market discussions for any of the regulatory frameworks that we have, whether that's a municipality asking questions about contracts with paints and coatings, or contracts for automotive, or contracts for tires. RPRA does not interfere with the market and negotiations occurring between producers, pros on their behalf, municipalities, or service providers. We certainly like to be made aware of how the implementation is going, what's occurring, what's happening as roadblocks that may deter or have issues for compliance down the road. So happy to have those sort of conversations, but we cannot give advice or guidance on private market conditions. You may want to speak to your association. And this works in multiple ways. We would not give advice to a producer who's asking us, what term should I look for from a pro? How can I pick my pro? What's the best rate I should get from my pro? A producer who calls us and asks us that, we encourage them to speak to their industry associations who have great resources to help them with those sort of questions. Equally, if a municipality or a service provider has questions about how the market is rolling out, certainly make sure RPRA is aware. So happy to be kept in the loop on these things, but advice on and guidance on it should be directed to your associations.
Thank you, Mary. So we also have a clarifying question here. What is the deadline for producers to hire a pro?
Oh, that's a good question. So as I said earlier, the April 1st is about the deadline that the reg says, the new regulatory amendments say for the 66%. So that's gone and passed. So now this question I think is more about, I'm a producer. I know I'm going to have management requirements. What's my deadline for selecting a pro? There is no deadline in the regulation. So any pro saying there's a deadline in the regulation, there isn't one, right? They may have deadlines from a market perspective, which I think everyone could appreciate is very fair, saying this is when we need to have our producers signed up, but there's no deadline on a producer. And that's just like every other regulation we have. And so a producer can do that how they need to, keeping in mind that they have important compliance obligations and requirements that need to be met. So that's sort of what you bump up against. At a certain point, you need to have met your obligations and your requirements in that regulation. And if you can't do it without a pro, and you don't have a pro by the time you need to be reporting that you've met those to RPRA, then it's a different type of a problem, and then you might have a compliance issue. So really, while there's no deadline, it's important to understand there's important implications to the timeline each individual producer decides on.
Awesome, thank you, Mary. Our next question here is, with the removal of Part 3 of the regulation, any reference to the Competition Act is removed. Does that mean they are no longer subject to the Competition Act?
So I don't believe that's what that means. I don't think any provincial regulation can unilaterally make it so that they're not subject to the Competition Act. I'm not sure about that, but I don't think that that's possible. And I think our statute speaks to the Competition Act, which is the overarching document. So regulations are just a component of the overall framework. The statute is actually the overarching document, and it's still included in that. Michelle, I see you nodding. Do you want to add anything?
No, I just wanted to confirm that the Competition Act is referenced in the RCEA, so that would be the overriding legislation.
Perfect, thank you.
Okay, and Mary, can you please clearly explain the reasoning for making an exemption for newspaper producers from managing and being responsible for the blue box material in Ontario?
Absolutely. So this again gets back to a question that's a little bit more linked with RPRA's role. I cannot explain the rationale or the reasoning. The folks who made this decision, it's a policy decision made by the government. So if you have questions about why, rationale, what made it happen, you'd have to speak to the government. RPRA does not play a role in those decisions. We simply take the regulation that's passed by cabinet and those policy decisions and ensure implementation and enforcement.
Thank you. So here there are clearly concerns about the transition program by both municipalities and producers. However, to date, we really haven't had a collective forum, including both stakeholder parties, to enable us to hear all parties' concerns. Presently, we, as municipalities and our service providers, manage the blue box material on behalf of all the stewards or producers. Upon transition, the stakes will be much higher for the producers if programs are not established in a seamless manner. Would RPRA or another organization consider formulating a collective forum for all of us to connect?
So the operations with an IPR framework and the transition that's occurred, RPRA doesn't have a role in the operations of these programs. This is really down to an individual producer responsibility and the pros acting on their behalf. So if producers, service providers, or municipalities want to see such forum, it's really the producer. It's a producer-led initiative. They are the ones now accountable for this. So I would encourage anyone who wants to see that producer, municipality, or service provider to speak to pros who are operating for the most part on behalf of producers to see if something like that could get going, but RPRA doesn't play a role in the operations of these programs.
Great, thank you. We have another question here. Is RPRA providing producers with a reference manual outlining the following, such as report submissions, portal guidelines, material definitions and expectations, brand holder hierarchies, and reporting requirements?
So yes, some of that material is provided in FAQs. So you can go to our website and get a lot of the answers to those questions that were just asked. You can also contact the team if it's a specific question. The reporting portal is being built right now, so there is no guidebook for it. There will be a guidebook on reporting once that's actually been built and delivered, which, as I said, it's more October 31st, which is the deadline. And in the meantime, if you have specific questions that you can't find the resource on our website, you can contact the team. While I know it may seem like a question is a frequently asked question to you, many times it isn't and doesn't necessarily require an FAQ on our website. But you can rely on the information provided by the team when they respond.
All right, thank you. So how will newsprint tonnage, generation and recovered, be considered in the verification of the management target of the paper category, i.e., will the generation tonnage be included in the denominator and recovered tonnage included in the numerator?
So newspaper tonnage gets to count towards the printed paper target. So yes, it will. As I said, all the producers are coming in reporting all their blue box tonnage. This has nothing to do with, it's still treated as a fully obligated material. This just exempts particular folks who have the total of that 70% from having to actually do any management collection or P&E, but newspaper still counts towards a printed paper target.
Okay, we have a question here on who are the pros who will be submitting the initial report by July 1st, 2022?
Well, that depends. We have registered pros right now on our website. The information is there on who has registered and declared as a pro. Who submits this initial report is up to them and how that works. Whether it's one pro, multiple pros, all of the pros is entirely up to the pros. But they are listed on our website under registrants.
Great. We also have a question here. What guidance can we give to multi-residential buildings in our municipalities regarding transition? If they currently have private waste collection that is not through the municipality, when can they register with RPRA so that they are part of the EPR program on January 1st, 2026?
So details on a facility and how they register might be better served by Michelle, who's handling that process. It might be something that she needs you to send in. One of the things that we've spoken about in other webinars is that RPRA takes a risk-based approach to compliance, which includes our communications, how we resolve answers and questions. So what that means is this regulation came out last year. It hasn't even been a year. So in order to effectively deploy our resources, we use this risk-based approach. So we say, what do regulated parties and entities need to know right now? So a question about something that's occurring in 2026 won't be something that necessarily we have all the details on. We're looking at the details of what producers or municipalities need to understand today in order to move towards 2026. So Michelle may not have a lot of detail on that process right now, just to set that expectation and why we don't have a lot of detail. Everything we do in order to effectively deploy our resources is looked at from that lens. Michelle, do you want to add any?
No, I think that pretty much covers it. I mean, I feel free to reach out. You can even address the email to me if that's helpful, and we can talk specifically about your concerns, and I'll give you as much information as I have available.
Great, thank you both. We do have a bit of a clarifying question here. I think a producer is not necessarily understanding the pro collection. So Mary, could you maybe give a bit more detail on if producers have to sign up with a pro and who do they sign up with?
Yeah, so if you have already signed an agreement with a pro and you did so before April 1st, any tonnage you reported in 2020 as 2020 supply to RPRA will be used to assist whether or not that pro meets that 66% threshold to submit the report to RPRA. If you have not done that by April 1st, you very likely still need a pro. You can take, there's nothing in the regulation that says you need one, but what you need to consider is whether or not you're going to have management requirements. So if you supply enough blue box material that you are not exempt, and the exemption thresholds are in the regulation, you will very likely have management requirements, which means that you are obligated to collect and to manage and to do P&E, which means that you will very likely want assistance with doing that and being part of the whole collection system, in which case you would want to engage with a pro. They're listed on our website. There's no deadline by which you need to do it, but what you have to remember is you have obligations. So if you know you have management requirements, if you see, okay, I'm not exempt, I'm going to have collection requirements, I'm going to have management requirements, I have to participate in this system, and you do nothing, and it comes time for reporting, you are a free rider on that system. So while there's no deadline and no requirement for you to get a pro, you very likely will need assistance in order to comply and not be a free rider later. I hope that clarifies. If it doesn't, I'm happy to answer again, or if you want to have more specific information or give us a call so we can walk it through a bit better if it didn't give you the perfect clarity. Happy to revisit too.
Also, I'd just like to point out that if there's a producer out there that's not sure whether or not they're going to have management or reporting requirements, they can also go to the producer webpage, Blue Box producer webpage, where we provide the thresholds. So you can very easily look at your 2020 supply data and compare those numbers to what the minimum supply-based thresholds are. And if you're over those numbers, then you know that you are going to have some kind of obligation that you need to fulfill. And if you're under those numbers, and then of course, if you need more clarity, we're happy to talk you through that. But that's probably your first step, is to just take a look at those numbers, and you can quickly eyeball and determine whether or not you are under or above supply-based thresholds.
It's great advice. And as I said earlier, like any market-based conversation, we can't help you with which pro might be able to provide your services to meet your needs, but we can certainly help you figure out whether you even need a pro. So feel free to contact us once you've determined that, using the tools on our website or talking to the team. It's up to you to figure out what risk you take. You know you'll have an obligation. You know you have a legal requirement to fulfill. How are you going to fulfill it?
Great. So we have a question here about the pros again. If a sufficient number of producers do not register with a pro, then no pro may acquire 66%. How do you deal with a stalemate amongst pros where there is no agreement on a common collection system?
That is a great hypothetical question. As best practice, regulators do not respond to hypothetical questions. So if that occurs and there's a stalemate, we will deal with it at that time. But until such time that is a reality of a fact of a situation that we're dealing with, I won't respond to hypothetical questions on different scenarios of what if this, what if that, what if this. We deal with the reality of what has actually occurred.
Perfect. And we have a question here. Can you please elaborate what section 5.1 subsection 3 of OREG 34922 means? Will other producers be able to take credit for the recovery rate of newspapers and then use it towards fulfilling their own recovery rate requirements under Part 6 of the regulation?
Somebody clearly has the regulation open when I don't. Michelle, the regulation, I can answer the question based on what it was at the end, but just make sure that the references to those sections are aligning with the answer I'm providing. Yes. So if Blue Box material is collected in that Blue Box material is newspaper, it can count towards the target. I think that's the short answer to the question. Maybe we'll move on to a different question. Let Michelle do a quick scan through those sections of the amendment and make sure there wasn't any sort of hidden Easter egg of a reference in there. But I believe that was the question that was being asked: is can I count newspaper towards my target if I'm not a newspaper producer and have printed or and have paper targets? And the answer is yes.
So what about newspapers that come under the small producer or de minimis threshold?
Yes, and that applies to all of them, not just newspapers. So let's say I'm a producer who comes under the $2 million exemption, but I still supply material into the market. A consumer still gets my material and still puts it in the blue bin. There's no way when it gets to a processing facility to pull that out. That gets to count towards all of the producers' management requirements, just like newspapers.
And we do. Oh, sorry, go ahead.
Sorry, I just wanted to pop in and say, yes, Mary's statement is correct, that they would be used. So so papers will not be dropped from being collected. They can be counted towards recovered resources by any other producer.
Thank you.
Great. We do have a bit of a regulatory question, Mary, that maybe you can shed some light on. So why are pros only requiring a description of how they will comply with the collection requirements of the regulation, while pros have to provide a detailed description of how they will make collected materials available for processing?
I would love to answer that question if I wrote that, but I did not write that. So you would need to direct that question to the folks who made that policy decision on what level of detail was required for different components, which is the ministry. So absolutely, let them know that you have that question. They might be able to provide you that clarity of what the policy intent was. All that RPRA and the registrar does is take what cabinet was approved, what is actually written, implement and enforce.
Thank you. We have a question here, a few questions here actually about pros. So maybe if we can just reiterate. One of them is about the amendment eliminated the allocation tables that should drive producers to register with a pro. Is it too late to do so? And if you haven't signed up and have an agreement with a pro, when should producers do that?
Yeah, so April 1st is gone, which was the date by which that 66% is the calculation, which is fine. You still very likely need a pro. So don't get stressed about the fact that you missed this April 1st concept, right? That's purely for the purposes of determining whether or not a document can be posted on RPRA's website. What you need to think about as a producer is, do I have obligations under this regulation? Like Michelle said, there's tools on our website. We happily to walk through a producer and figure out if what their obligations might be. If the answer is, I have obligations, I have management requirements, I need to participate in the collection system, I have P&E requirements, you will very likely need a pro to assist you in doing this. You have dates by which you need to have achieved those outcomes in the regulation. So while there's no deadline that says you have to select a pro by December 31st of 2022, you need to think about what are those dates by which I need to have performed against my requirements in the regulation, and then backstop that against your own business. How long does it take for you to negotiate a contract and get it through and everything else? Are you RFPing? How does your procurement process? So these are very individual market-based conversations for each individual producer, but really what it gets down to is you're procuring a service just like any other service that you would procure. So you need to look at it and say, just like any other service that you need as a company, how am I going to procure the service I need? And by what date do I need to procure it by in order to comply?
Perfect, thank you. And there's also a question asking, did the RPRA board vote on the newspaper publisher exemption, or was it just handed down by the province? I think a great regulatory clarifying question.
Another, yes, a good one. And I'm sensing lots of questions. It might even be a good idea for us at some point to put together something very specific to folks about what RPRA and our board's role is and what the registrar's role is. So perhaps this is something, it seems to be a topic of great questions. So maybe we'll look at doing that for folks. But RPRA does not set policy. RPRA does not determine what the regulations say. The board had no involvement whatsoever in the drafting or this law becoming law by cabinet. The registrar has no role in it whatsoever. The ministry is the one that sets the policy and makes these decisions, writes them into a law that cabinet then passes. RPRA implements and then enforces what's been written. We don't get a say or any feedback or anything in policy decisions. Those are solely set with the government.
Great, thank you. And are magazine publishers exempt in the same way as newspaper publishers?
The exemption applies to very specifically newspaper only in terms of if you've hit that definition of the 70% for newspaper. I don't know if we want to pull it up there again for folks, but for the purposes of the regulation, newspapers are made of newsprint only and include any protective plastic wrapping and any supplemental advertisements and inserts that are provided with the newspaper. Newsprint only. I hope that answers the question. If you have a very specific question, like, is this, give the team a call and they will let you know if you're very specifically trying to figure out one item, especially when it comes to reporting October 1st. You'll have that guidebook that gives you the examples of what to include when you tell RPRA, here's all my blue box material and what percentage of that was newspaper. Perfect, thank you.
So here we have, as CMO has announced, it will not pay processing costs to municipalities, and they intend to use the 2020 data call to estimate payment allocation through transition. Can we amend our 2020 data call to reallocate processing costs that should have been applied to Depot?
That's a question for the data call team on what amendments are allowed and for what rationale and what reason. And there's a committee that's involved in that, involving municipalities and stewards and Stewardship Ontario, represented by Stewardship Ontario. So that's a question under the Waste Diversion Transition Act and the data call itself. So if anyone doesn't have the data call contact information, I'm sure you do, because for many, many years you've dealt with that team. But it is available on our website as well, who and how to contact the data call team to find out that answer.
Thank you, Mary. Just having a look at these other questions that are coming in. So this is a clarifying question on one that was brought up before. So it's, how is RPRI interpreting, implementing, enforcing, whether it is receiving reports, so the pro initial report, that comply with the report details in the regulation as per the original question. So why are pros only requiring a description of how they will comply, whereas, you know, they have to also provide a detailed description on collection?
Yeah, so again, questions about why it's written the way it is best put to the folks who made the decision to write it that way, which is the government, and they're the ones that set that policy. RPRA's role in this is we receive it. If it represents 66%, we post it. That is it. That is how we implement that section. I want to be clear, no enforcement, we are simply taking a document, confirming some math, and posting it on our website.
Great. A few more questions about pros. So if a producer registers with a pro after April 1st, does this mean their tonnage is not added to the numerator to determine the percentage of pro controls?
Correct. That is what is written in the regulation. Doesn't mean you still don't need to do that picking a pro concept for much, much more important reasons, which is being able to comply with the regulation overall.
Great. So we still have about 5 more minutes left in this. I'm just going to take a quick break from the questions, and we're going to launch our feedback poll so that we can determine how to improve our webinars. And so please fill out the 4 questions. I'll leave it up for a few minutes. And then, as I mentioned, we'll get back to questions. Few more seconds that people finish out the poll. Okay, perfect. I'm going to stop now and I'll quickly share the results. Okay, perfect. Thank you so much, everyone, for filling that out. We'll get back to questions now. So we have a question here. How would we know which pro or producers will be responsible for the collection in a particular municipality so we can discuss transitional issues in that municipality?
You should contact the pros. All of the operations, so how this will work, what service providers operate where, all of that is part of the producer's ability to operate now and is being performed by the pros on their behalf.
Thank you. And we have a question here that says, I understand that the producers need an agreement with a pro and that the pro will submit the report on October 1st, or is it that the producer needs to submit the report on October 1st, or sorry, 31st?
Yes, so the way that the registry portal is set up for all regulations, right? So not just Blue Box, producers have an account and they can assign users to that account. Producers are required to register with us, not the pro. The pro doesn't register on behalf of the producer registers with RPRA. They'll get a registry account and they can authorize users within their account, whether that's a summer intern who fills out data for them, whether that's somebody in their company or whether that's somebody outside their company is up to the producer. It's the producer responsibility to ensure it occurs, though.
Great. We just have a few more minutes here, so I'm going to try and do 2 more. So we spoke to a pro in October, and they suggested we didn't need a pro until 2023. Is RPRI suggesting that we need one by July?
I'm not giving you a date. I'm suggesting that you do your due diligence as a producer and say, do I have obligations? Do I have requirements to meet? The program transitions July 1st of 2023. What is your internal process like for selecting and procuring services on behalf of your company? There's no date. This is an individual decision for each producer. But what I can say is that pro wasn't incorrect. Your obligations aren't beginning until July 1st of 2023 in the sense that that's when management collection is beginning. When you actually initiate those conversations, when you need contractual arrangements signed, that's very much so your individual company's decision in terms of how you procure services.
And we have a question here about reporting deadlines. Why do producers have until October to report their date and municipalities only have until the end of April?
I'm not sure what end of April is for municipalities. There is nothing due end of April for municipalities. If you're speaking about the transition, require like transition reports, I think those are due in, I want to say August.
Yeah, for 2024 transition is due August 31st, 2022. As far as I'm aware, there's no municipalities have different dates. Municipalities as producers have the same obligations to register and report as every other producer. So there's no difference between if the context of that question was a municipality reporting as a producer versus a different producer. Everybody has to report at the same time.
There's a clarification here that they meant it's for data call.
Oh, data calls under the Waste Diversion Transition Act. It's a completely different statute, completely different deadlines, completely different reasons the data is needed. All of it is apples and oranges. There's absolutely no correlation between this regulation and what's required under the Waste Diversion Transition Act and the Blue Box Program Plan.
Perfect. So we're just coming up on the last minute here. So Mary, if you would like to have any closing remarks, we would like to thank everyone for all the questions that they've put forward as well.
This was great. I hope folks found it useful in terms of having it as a forum like this. And if so, happy to try to host more than just this type of one on different subjects, and also clearly looking at speaking with the team internally about getting something, a webinar on RPRA's role. We've done it in the past, but perhaps we need to do another one to help folks acclimatize to what RPRA is responsible for versus other parties. So I want to say thank you to everyone, including the RPRA team who helped support this.
Thank you so much. And as mentioned, this session is being recorded and the materials will be shared with everyone after. Thank you so much and have a great day.